Doesn't feel like that long since I last saw you, but it has been a while. So hope you all had a lovely Christmas and New Year, got some time to relax, celebrated with your families. You're still keeping up with your evidence work, right? Not really. Then now's the time to revisit it, right? Before you start to race towards the exam. All right, so here I am in wearing a different hat, this time for criminal procedure and advocacy. I'm going to start with a quick overview of the course, and then we'll get into the first lecture. So I've uploaded for you a reading list that you should have on Soul. The key text for you to take a look at is the Criminal Procedure in Hong Kong text by Kansi Liu. You don't need to purchase a copy. I think that these notes are pretty comprehensive, but if you can read some of the recommended reading at some point, I think that would be very helpful. As well, if you're ever struggling with an issue, then Archbold is the leading text for you to consult. And it's a really good starting point always, as well as the Crotts and Chung book on sentencing. But these are starting points only, right? You always need to go to the underlying cases and statutory provisions and read those yourself. So you should be able to find all of the ordinances you need on the Hong Kong Bliss bilingual laws website, the e-legislation link. And also Amanda Whitford's book on criminal procedure in Hong Kong is a really good practitioner text, so that has lots of useful tips in it as well. In the reading list as well, I've put out some key ordinances for you to take a look at. The main ones are the criminal procedure, magistrates ordinance, district court ordinance, the police force ordinance, and costs in criminal cases ordinances. Because this is an open book exam, which I'll get into in a minute, that means that Space won't provide you with copies of any documents going into the exam. So you need to bring everything in yourself. So you're not going to have copies of any of these ordinances with you, right? So I think it's a good idea for the key ordinances in particular that you have copies available in case you need to consult some of the provisions. But there's some other ordinances as well that we'll be referring to a lot, primarily the ones that deal with sentencing, like the probation of offenders ordinance, community service ordinance, etc. And then we're going to touch on some other ordinances like the theft ordinance, offences against the person ordinance as well. Okay. I've already asked Bessie to upload the 1992 rules and directions, which you know a little bit about already from your evidence law classes, but we'll go into them again in a lot more detail on this course. And as well, there's the 2012 internal police version that you can also take a look at. We're also going to look at the prosecution code, as well as the victims charter and the statement of treatment of victims and witnesses. But you can view all of these documents online. I've only given you the rules and directions, because that's the main one. So in terms of how this course is going to break down, obviously this is a course that's focused on criminal procedure. And it's going through the rules, explaining the rules on criminal procedure, but it's also very practical in its nature, because you can't practice as a lawyer in Hong Kong without understanding the rules of criminal procedure. And so this course is really designed with that in mind. So I think you will find it a lot less theoretical than some of your other LLB courses that you're taking. And you'll see when we get to the past exam papers, they're very practically based in terms of you're usually working from a fact pattern and being asked to advise the client. So what you learn on this course really will assist you a great deal if your ultimate aim is to practice as either a solicitor or a barrister in Hong Kong. And of course, it's a good precursor to what you'll study on the PCLL when you graduate from here, right? So we're going to look at case law, statutory provisions. We'll look at the procedural rules. There's many guidelines, many practice directions. As we go through, I'm going to give you a lot of practical tips as well that you won't necessarily find out if you just read some of the textbooks. We'll also, of course, look at the national security law, because that is a really important aspect these days of criminal procedure in Hong Kong. And there are many differences between the criminal procedures under the national security law and under our general criminal provisions. And once we have a good basis of the procedural rules, you're then going to apply your knowledge in the tutorial. And the tutorial I think that the students worry about the most is the advocacy tutorial, where you're going to perform a bail application. But before you get there, I'm going to teach you everything you need to know about bail. I'm going to do a demonstration for you of bail application. I have lots of tips for you to apply in your bail application. So don't worry about it. I have never had a student die in a class performing a bail application. And I can confidently say that that will continue to be the case this year. You will all survive. You'll all learn something from it, and it will make you much more effective students and lawyers as well. All right. So if you've taken a look at the notes already, you'll see that there is a lot of background reading that you need to do. So my expectation is, coming into these lectures, you've looked at all the slides, you've done as much background reading as you can, and take a look at some of the statutory provisions that are cited, so that in the lectures we can really focus on going through the key points. Because like all of the courses that you do, this is really like a boot camp, right? We only have 6 lectures in the course of the next 2 weeks. And this is a subject that I would usually teach over an entire semester, right? So this is a really accelerated version of it, and you have to keep up from the very beginning. It's also going to be quite interactive. So we'll use Mentimeter. I'll ask you questions throughout the lecture as well for you to answer. And I'm going to give you some demonstrations. The first demonstration I'm going to do for you is in lecture 3, which is next Monday. And I'm going to demonstrate to you how to perform a bail application. You have all of the materials that you need to review already up for you on Solve. It's the case of Hong Kong SAR and Romeo Chan. So in my opinion, it's pointless if you come along to lecture 3 on Monday, not having looked at all at any of the materials connected to Romeo Chan. And you just sit there and you just listen to me make a bail application. You won't learn very much from it. What you need to do in advance is make sure that you've read the brief facts, the charge sheet, the brief to counsel in that case, and that you've thought about how, if you were going to make a bail application for this client, you would perform it yourself, right? Ideally, you should draft some points, right? You should plan it, plan out the bail application that you would make for this client before Monday's lecture, so that you, when you watch my demonstration, you A, understand what on earth I'm talking about, because you're familiar with the facts, and B, you can then think about how my approach is different from what you may have planned to do, right? And then my aim is, at the end of it, we can then have a discussion about, why did I say this? Why did I not include this? What would you have included that I didn't include, and why? All right. So if you do that, I really think you'll get the most out of the demonstration, and you'll be in the best possible position going into tutorial 2, where you then have to stand up and perform your own bail application, right? Because the only way you can be an effective advocate is by actually performing the skill yourself. You can never be a good advocate if all you do is just sit there and listen to someone else making a bail application. It is so much more difficult in practice when you are up on your feet and you're having to answer questions from magistrate or judge. than it is if you're just sitting there listening and observing, thinking, wow, that looks easy, right? Of course it looks easy, because the chances are the person making the bail application has done it 100 times before, right? But it wasn't easy, certainly wasn't easy for me on goes 1, 2, 3 to 50, all right? It's something that you develop with practice. And that's what I want you to do, right? So I want you to critically analyze, think about what you would do going into this lecture on Monday. Then you're going to perform it in your tutorial, and then we'll have feedback on that, and then we'll do the assessment, okay? In terms of the timetable, we've got 6 lectures this week and next week. We've then got 2 tutorials. One is just on criminal procedure questions, like you'll get in your exam. The other is the advocacy tutorial. So for the first tutorial, you attend for the entire tutorial. The second tutorial, just to save you a bit of the monotony of having to sit there and listen to 30 students performing a bail application, we've divided you into 2 groups. So you only attend for your allocated group within that, on that particular day. And there are 2 briefs, so you'll be assigned a particular client, right? So you prepare the bail application for that client that you are assigned. Then we have a feedback lecture after the tutorial. So the purpose of the feedback lecture is for me to go through the feedback as a group that you received from me and from the other tutor, so that we can consolidate all of the feedback together. And then also I'll demonstrate the bail applications that you made, and then we can discuss it. And then we have the advocacy test. So again, you get allocated your time slot. You only attend for that particular time that you've been allocated. It will be very short. I think you get like a 5-minute time slot or something like that. You are there by yourself with the assessor, who's me in the room, just the 2 of us. And you all have the same brief. So the playing field is level, right? Everybody has the same experience, but you don't get to listen to anyone else performing the bail application. It's just you by yourself. And then we have 2 revision lectures towards the end of March to prepare for the written exam, which I believe is sometime in May. Okay, so keep up as we go through the course. Your written exam in May, it's open book. It's only an hour and a half. So time is tight, which means that you have to come into it fully prepared, not relying on your notes. Of course, you have notes with you, right? But you treat it like a closed book exam, even though it's open book. You come in with all the knowledge in your head so that you can spend the entire time writing, because it counts for 80%. And then your oral advocacy test, which is the bail application, counts for 20%. And you only have about 3 minutes to make it. So time is very tight. But you can bring whatever you want into the written exam or the advocacy test. Obviously, you just can't use anything online. So I gave you a few exam tips here. I think you can read these through for yourself. And we'll go through a lot more of them as we get to the revision lectures and the advocacy specific lectures. But my top tip for the advocacy is not to read through your notes. In other words, what I mean is don't just stand there reading from your notes, because that's not what being an advocate is about. You have to have good eye contact with your audience, and in other words, the judge or magistrate, to be able to persuade. So when we do the demonstration and we talk more about the advocacy exercises, I'll give you some more tips as well. And actually, I've set out a lot of tips for you in writing already in the student instructions. So start to take a look through those, because it includes many things like having bullet points that you can just look down and grab a point out from your notes on the table rather than reading from a script, and preparing the other side's case as well as your own. So obviously, when you're making a bail application, you're making it as a defense counsel or defense solicitor. But that doesn't mean you just prepare your arguments from the defense perspective. You have to prepare what you think the prosecution is going to say. Because when you prepare the other side, it helps to show the weaknesses in your side. And then you can think about how to counter their argument. And that's critical in making a bail application. And of course, you want to practice. So going into this tutorial 2, where you're going to practice making a bail application, you have to have done so much preparation. Last year, I had a couple of students who turned up and said, actually, I don't want to have a go. I haven't prepared. I just want to sit here and listen to what everyone else is saying. And I told them to go away and come back prepared for the next day's tutorial and perform it with a different class. Now, why did I say that? Because this counts for 20% of your mark, and you're not going to pass if you haven't practiced, or you're going to find it very difficult to pass if you haven't practiced. So I really felt they were doing themselves a huge disservice in opting out of the practice session. So you need to prepare for it. You can't just stand up and wing it. You have to know the facts. You have to know what points you're going to argue. You have to be prepared for questions, because you will get asked a couple of questions during your bail application. Okay, which again is why you can't just read from the script, because I'm pretty sure your script is not going to have the exact place at which I'm going to ask you questions or what those questions are going to be in it. Okay, like with all of these courses, right? Obviously, you can't copy from any of the notes or slides or anything. What you write in the written exam has to be your own words. So tonight we're going to cover basic introduction, which we're almost at the end of, the fundamental rights of the defendant. We're going to go through the criminal court structure, talk about the jurisdiction of the various different criminal courts. Briefly, we'll talk about the national security law, and then we'll look at the role of the prosecution and what government assistance is available for the representation of defendants. And then we'll look at police powers, primarily focusing on the power to stop, detain, and search and arrest. We'll look at the fact that even a private citizen in Hong Kong can actually perform an arrest on someone. We'll look at what a lawyer does when their client's arrested and the rules and directions. Tomorrow's lecture, we're going to talk about the decision, how that decision is made to prosecute, what the limitation periods are, and the various different ways that proceedings can be commenced. But a big part of tomorrow's lecture is going to be focusing on the bail rules and the different procedures. We'll talk about the different conditions that can be imposed on bail. We'll talk about the different types of bail that can be granted and the different stages during the criminal process that bail can be granted. And what happens if the bail conditions are breached or if the defendant absconds? What are the consequences? And we'll also look at the different types of offenses and basically how a criminal case moves through the different courts. Lecture 3 is the demonstration of the bail application. We're going to look at a bit of stuff that happens pre-trial. For example, when prosecution and defense negotiate between themselves for an alternative outcome. And we'll look at what happens when the defendant decides he wants to plead guilty and then subsequently changes his mind. Lecture 4, you can see that most of this slide is highlighted. Now, the reason I've highlighted it is not because the other content can't appear on your exam, because everything in the slides and the materials that you get can be covered in the exam. But I highlighted this in particular because these are really key points that come up frequently in past exam questions. So I really want to focus your mind on those. So for example, can you cross-examine a defendant on his previous convictions? You know a little bit about that already from evidence and also similar fact evidence. We've also touched on disclosure as well. We, I think, talked about the different directions that a judge has to give to a jury, including where it's alleged the defendant has told lies. There is also a section in your evidence notes on formal admissions that can be made. So this is all going to be a bit of a refresher. We'll refresh our memories of different types of protections that are available for witnesses who are in a special category. We will look at when the defense tried to have a confession ruled inadmissible and the different procedures and the different arguments that they can make. We'll look at ID, no case to answer submissions. Lecture 5 is also critical because that is an entire lecture that's just devoted to sentencing because it's such a huge topic. So we'll go through the vast majority of sentences that can be imposed post-conviction upon a defendant. And we'll look at the different types of sentences for an adult versus a juvenile or young offender. We'll look at how the sentencing judge makes his decision, like what guides him to impose a particular type of sentence, and if it's a length of, if it's imprisonment, how long that imprisonment should be. And we will spend some time talking about pleas and mitigation as well, but not too much because that's also an important advocacy exercise, but it's much more difficult than doing a bail application, which is why for your assessment, you're doing a bail application, not a plea and mitigation, because plea and mitigation is a lot more of an advanced skill. And then lecture 6 is the final substantive lecture. So we'll talk about costs. We'll look at the special procedure in the magistrate's court if you want to review a magistrate's decision. When we talk about appeals, we're going from a lower court to a higher court. But this review provision in the magistrate's court is where you stay within this level of court, you stay in the magistrate's court, and you ask the magistrate to reconsider the decision that he's made. So we're going to look at appeals from the magistrate's court, as well as from the district court and the court of first instance. We'll briefly talk about appeals from the Court of Appeal to the CFA, and then we'll look at some of the relevant provisions as well. So again, I've tried to highlight some of the main points. This fourth bullet point here, Secretary for Justice's appeal by way of case stated against an acquittal by a panel of 3 judges. This is a special provision that was just recently introduced, whereby if a national security case has been tried by a panel of 3 judges and they have acquitted the defendant, then there is the possibility for the SJ to appeal. Now, to my knowledge, this has not happened so far because no defendant in a national security case has been acquitted so far. But there is this possibility of the appeal. All right. And then we have the tutorial. So as part of your second tutorial, right, obviously you're going to prepare your bail application, but you must bring in a recording device so that you can record yourself, and not just an audio recording, like a video recording. So your iPad, laptop, smartphone, whatever it is, okay, you must record yourself. Why? Because I think it's critical to view self-evaluating your own performance. I want you to review the video of your recording afterwards and think about how you could have improved it. Because one thing I think you should always do, and I'm sure even very experienced practitioners do, is when they leave court having just made a submission, is to think, how could I have improved on it? Right? How would I do it differently? What did I say that I could have said better? Or what did I say that I shouldn't have said, right? So it's a constant learning process, developing that skill as an advocate. So that's the purpose of you recording yourself. So you don't have to show it for family movie night, that the whole family gathers over popcorn and has a laugh at your first attempt at a bail application, right? It can be for your eyes only, but I do want you to record it. All right, so that's the overview. Are we ready to start lecture 1, or are there any questions? No, we're all good? Okay. So let's start with some key principles and a little bit of a refresher. So I'm sure we all know about the presumption of innocence, right? But it's not an absolute right. When we talk about the presumption of innocence, what we're meaning is a person is presumed to be innocent until proven guilty, right? In other words, it's the prosecution who has the burden of proof. But it's not an absolute right, because there are some offenses that we'll see where absolute liability is imposed or strict liability is imposed. That's kind of a derogation from this presumption of innocence. But it has a constitutional basis, right? It's in our Bill of Rights, it's even in the national security law. But because of this presumption of innocence, it means that in our criminal system, it's the prosecution who bears generally the legal and the evidential burden of proof. So the prosecution has to prove that the defendant committed all of the elements of an offense. And if they fail to prove just one of the elements, like let's say for theft, right? Theft is the dishonest appropriation of property belonging to another with the intention of permanently depriving them of it. There's basically 5 elements to the offense of theft. Failure to prove one of those elements means that they haven't met their legal burden of proof. So because of the presumption of innocence, the defendant is entitled to be acquitted. But we have some exceptions, right? Because we have what we call offenses of absolute or strict liability. So if it's an offense of absolute liability, it means that the defendant is guilty just on proof that he did the guilty act, right? He performed the actus reus. That's what an offense of absolute liability is. If it's an offense of strict liability, then the defendant is presumed to be guilty if he's performed the actus reus, but he can raise a defense of honest and reasonable belief, right? For absolute liability offenses, there is no ability to claim that you had an honest and reasonable belief in a different state of affairs, right? You're just guilty. So that's the difference between absolute and strict liability offenses. So there's an example here. For example, when it comes to unlawful sexual intercourse with a girl under the age of 16, that's an offense of absolute liability. In other words, it doesn't matter if the defendant said, oh, but I thought she was over 16. I thought she was 21. Doesn't matter. That's an offense of absolute liability. But on the other hand, the offense of indecent assault on a child under the age of 16, that's an offense of strict liability, because the defendant can raise the defense of honest and reasonable belief. So in general, the common law and statute places the legal burden of proof on the prosecution. But in some circumstances, that burden of proof is placed on the defendant to prove his defense, right? So for the example of the strict liability offense, the defendant has the burden of proof to prove that he had this honest and reasonable belief. So you'll remember from our evidence lectures that there are some common law examples of where the defendant has a legal burden of proof, right? You remember the defense of insanity, McNaughton's rules. In that case, if the defendant wants to run a defense of insanity, then he has the legal burden of proof to prove that he was insane, right? That's a common law shifting of the legal or persuasive burden of proof. Where he's charged with murder and he wishes to run a defense of diminished responsibility, then we have Section 3 of the Homicide Ordinance. That's a statutory shifting of the legal burden of proof. It's for the defendant to prove that he was acting under diminished responsibility at the time of the murder. And diminished responsibility in any event is not a complete defense. It's only a partial defense. Because if the defendant is successful in his claim he was acting under diminished responsibility, then the charge is effectively reduced from murder to manslaughter. So he will be guilty of manslaughter, but not guilty of murder. Another example is the provisions in Section 94A of the Criminal Procedure Ordinance. So what we call the negative averment. So you'll see that for some offenses, it's an offense to do something without lawful authority, or without a license, or without reasonable excuse. What Section 94A says is that the prosecution do not need to prove or counter the negative, right? They don't need to prove that the defendant did not have lawful authority, okay? If the defendant wants to run that defense, he has to establish that he did have a license, he did have lawful authority, he did have a reasonable excuse. In other words, the onus, the burden of proof is placed on the defendant. So an example, let's take, well, we can take something relatively minor, right? Like in Hong Kong, all bars that sell alcohol have to have a license in order to be permitted to sell alcohol, right? If they're charged with an offense under that ordinance, then it's for the bar owner, the responsible person, to prove that they did have the license to serve the alcohol, not for the prosecution to show that they did not have the license. The reason behind this section is that really when you're talking about an individual's responsibility, they are best placed to be able to make that argument. It's the same as for the insanity argument under McNaughton's, right? If the defendant wants to argue that he was insane at the time the offense was committed, the best person to prove that is the defendant, rather than for the prosecution to prove the contrary. Sometimes, though, the defendant just has an evidential burden. So even though the legal burden of proof remains on the prosecution, the defense may have an evidential burden. For example, if the defendant wants to raise self-defense, in other words, he committed the assault, but only because he was acting in self-defense, then he has the evidential burden to raise it. And you'll remember that the test for the legal persuasive burden and the evidential burden is different. Okay, so where the defendant has the evidential burden, he just has to establish a prima facie case. In other words, some evidence that is not fanciful. It's a very low threshold burden, as opposed to where the prosecution has the legal burden of proof in a criminal case. They have to prove the elements of the offense beyond reasonable doubt. That's a very high burden. Where the defendant has the legal burden of proof in a criminal case, the defendant only has to prove it on the balance of probabilities. So that's somewhere in the middle, right? More likely than not, 51% versus 49%. But a prima facie case is much lower, just some evidence that is not fanciful. We also have presumptions that we learnt about in evidence law as well. Remember, common law and statutory presumptions that may attempt to shift the burden of proof. So when we look at Section 44 of the Dangerous Drugs Ordinance, for example, what that provision provides is that if a defendant is found to be, let's say, in possession of a key to a locker in which there are drugs, then he's presumed to be in possession of those drugs, right? He doesn't have to physically have the drugs in his actual possession if he has a key to where the drugs are placed. And Section 47 also provides that if he's presumed to be in possession of the drugs, then he's presumed to know the nature of the drugs. So two different presumptions in Section 47. But the Court of Final Appeal in Hung Chan-Hua said that this statutory provision was actually a derogation of the presumption of innocence. So what they did was, instead of the legal burden of proof that's placed on the defendant in Section 47, they read it down to just be an evidential burden instead. So they applied a much lower threshold of the burden of proof on the defendant to just raise a prima facie case that he didn't have the drugs in his possession. and then the burden shifts to the prosecution to prove that he did. So we'll also spend some time talking about the right of silence, because there's a recent case from the Court of Final Appeal, which you may be familiar with, the Chan Chu Leung case, which clarifies a lot of the uncertainties that existed about the scope of a defendant's right of silence in court and outside of court, and attempted to clarify it because it was felt that the approach was not always applied consistently in the courts. In other words, there were a lot of inconsistent decisions being made by judges and magistrates about whether the defendants had a right of silence not to answer questions or not to reveal information. But this isn't an absolute right as well, because there are certain statutory provisions which require a defendant to provide information, usually for very serious offenses like prevention of bribery or under the national security law. You do not have the right to remain silent. You must provide the information or you commit another offense. But if the defendant does have this right of silence, if you've ever watched like American courtroom dramas, right, you'll have seen the witness, he's always taking the fifth, right? In other words, he's refusing to answer questions. He's pleading the Fifth Amendment to the Constitution, which gives him his right not to incriminate himself and to refuse to answer questions. So our right to remain silent is sort of a similar thing. Although in court, if you're asked questions, you do have to answer those questions. So we also have our Bill of Rights as well, which sets out some of the fundamental rights: right to be informed of the nature of the charge promptly, that there shouldn't be undue delay in your trial, that you cannot be convicted of offenses retrospectively. In other words, you can't be convicted of an offense which didn't exist at the time you did the act. And you also have a right of appeal. I just want you to note right at the start that there is no common law right of appeal. There must be a statutory basis for the appeal. So if you cannot find an argument, or if there is no statutory provision allowing you to appeal, you don't have the right of appeal, okay? We'll talk more about that in lecture 6. So let's talk briefly about the criminal court structure. So assuming that proceedings have been commenced, and we're going to look at the various different ways in which proceedings can be commenced, every criminal case, whether it is a very minor traffic-related incident or the very most serious type of murder that could ever be committed, everything must always begin in the magistrate's court. There's no sidestepping that. So a defendant's first appearance will always be in the magistrate's court. After that, depending on whether the defendant pleads guilty or not, depending on the seriousness of the charge, it may be moved to a different court. So we sort of have the magistrate's court as the lowest level of the court of trial. We have the district court, which can also be a court of trial, but for more serious offenses than are heard typically in the magistrate's court. And then we have the court of first instance, which is regarded as the highest court of what we call original jurisdiction. What we mean by original jurisdiction is a court of trial. So in other words, the magistrate's court, the district court, and the CFI are all courts of original jurisdiction in the sense that they can all hear trials if the defendant pleads not guilty. But then we have other courts that are appellate courts, right? So we have the Court of Appeal, we have the Court of Final Appeal. But actually, the Court of First Instance has two jurisdictions. It can be a court of original jurisdiction because it can be where the trial is heard, but it also has an appellate function because the Court of First Instance can also hear appeals from the magistrate's court, and that's when it sits in its appellate jurisdiction. So if the Court of First Instance is sitting in its appellate jurisdiction, then any appeal from that decision has to go to the Court of Final Appeal. And we'll talk more about this when we get to lecture 6. So in the next few charts, we're going to look at how the proceedings are slightly different in the 3 courts of original jurisdiction. There are various different magistrates' courts in Hong Kong, and if you ever have the opportunity to go sit in some of them, I think it's a really valuable experience. You go sit in Court 1, in any of the magistrates' court, you'll hear lots of bail applications, lots of pleas and mitigation. Unfortunately, I can't promise you there'll be good ones. It's going to depend on who's making the bail application. You might see a lot of what we call a standard green form mitigation, which is where the counsel just stands up and reads out a shopping list of all of the facts. But it's definitely a good experience of the different types of offenses that you can deal with in the court. If the defendant pleads guilty, then we're not heading towards a trial, right? There can be what we call subsequent mention hearings or sentencing hearings, but we don't have a trial. Whereas on the other hand, of course, if he's pleading not guilty, then there's going to be a trial. And right from the beginning, I want you to get your language, your terminology correct. So all cases begin in the magistrate's court, but then depending on the seriousness of the offense, it may either be transferred to the district court or it may be committed to the CFI. So there's a difference in the terminology that we use. We transfer to the district court, we commit to the CFI. What's the reason for the difference? It's because in order for the case to be committed to the CFI, there have to first be committal proceedings in the magistrate's court. And then you get to the CFI, and in the CFI, there's a judge, but there's also a jury for general criminal cases, not under the NSL. So before, though, we decide, or the defendant gets the opportunity to decide, right, there would be on his plea, there'll be, first of all, obviously, discussion with counsel, with the solicitors, so that he can make an informed decision on his plea. But one thing we need to think about is if the defendant is going to plead guilty or plead not guilty, where can he do so? If the prosecution have decided that the case is going to be tried in the magistrate's court because it's a minor offense, they will ask for plea to be taken in the magistrate's court. Or usually, to save time, they just stand up and they say, for plea. That's it, right? So that means that they have decided that the magistrate's court is the most suitable venue. And then the defendant, the charge is read out to the defendant, and he's then asked whether he pleads guilty or not guilty. So it's entirely his decision whether to plead guilty or not guilty. But it's really important that's an informed decision, right? In other words, made on the basis of legal advice about the strengths and weaknesses of the prosecution case, about whether he has any defense available, about the likely sentence that he'll receive. If, though, the prosecution have decided that this is too serious a case to be heard in the magistrate's court, they may ask for the case to be transferred to the district court. So usually they won't do that on the defendant's first appearance in the magistrate's court because they need time to prepare. So the case will be usually adjourned from that first appearance, maybe several times, until the prosecution have decided on what's the appropriate venue. And if they've decided that it's the district court, at that point, they will submit the transfer papers to the magistrate and ask for it to be transferred. And actually, we'll look at later, but the magistrate doesn't have much choice in the matter when it comes to transferring the case to the district court. But if it's being transferred, plea isn't taken from the defendant in the magistrate's court. He has to wait till he gets to the district court. And then on that first appearance in the district court, there's a very funny procedure, which is called an indication of plea. In other words, he just indicates whether he's going to plead guilty or plead not guilty. The idea is that on that first appearance in the district court, it's a little bit like being in a market, right? There are hundreds of cases all there, hundreds of people all at the same time. And so basically, to save time, the defendant just indicates his plea. And it's done from a case management perspective. Because if he indicates that he's going to plead not guilty, then the court can look at its diary and fix time for a trial. If he indicates that he's going to plead guilty, what happens is that the district court judge will then adjourn the matter for a separate plea and sentencing hearing on another occasion. So the idea is to shorten the time that's required on this first appearance in the district court. If the prosecution have decided the CFI is the appropriate venue, though, then the defendant can actually plead guilty or not guilty in the magistrate's court. If he pleads guilty, he's then committed to the CFI for sentencing. If he decides to plead not guilty, then he has the choice of the way in which he's committed to the CFI. And we'll look at that in a bit more detail in another lecture. But if he is committed to the CFI, plea is taken again from him when he gets to the CFI. So basically what you need to remember is that if the case is being transferred to the district court, plea is not taken from the defendant in the magistrate's court, only when he gets to the district court. So let's start with the magistrate's court, okay? So this looks like a very complicated flow chart, but as we work through the course, you'll see that it's really not. So we start off with the various different ways in which a defendant can be brought before the court. How can proceedings be commenced? Then he makes his first appearance in the magistrate's court. It's always in court one, because that is the main court, that's the plea court, it's the busiest court. And then the decision is made as to when plea is going to be taken. And then based on that, various different things can happen. And you can see there on the left-hand side that, on the right-hand side, sorry, that the case may then be transferred to the district court, or there may be committal proceedings to the CFI. So, magistrates' courts. You need to be familiar with the provisions of the magistrate's ordinance. We'll go through the main sections with you, and there are some also relevant provisions of the criminal procedure ordinance as well. Maximum jurisdiction of the magistrate's court is 2 years imprisonment. But where the defendant is being sentenced for more than one offense at the same time, the magistrate has the jurisdiction to impose up to 3 years sentence if the sentences are imposed consecutively. So the maximum can be extended under Section 57. Whenever you're appearing in the magistrate's court, you always address the magistrate as either sir or madam. If you're not sure whether it's a sir or a madam, or you want to be politically correct and be gender neutral, then your correct form of address is your worship. And the person charged, the prosecution will always refer to them as the defendant. From your perspective as defense counsel, right, you can refer to them as the defendant, you can call them my client, or you can call them Mr. Wong, Miss Chan, by their last name. And when we get to bail applications, I'm going to ask you which of those three phrases, what we call tags. Tags are labels that we attach to person, a place, a thing, right? Which of these tags, defendant, my client, or Mr. Wong, you think is most persuasive from defense team's perspective? Because advocacy is all about the art of persuasion, right? And whenever you're making a bail application, or even a plea in mitigation, you're starting off from the bottom of the hill, right? You're already facing a little bit of resistance from the court. With a bail application, although there's the presumption of innocence, and we'll talk about the presumption of entitlement to bail, at the end of the day, this person's still being charged with an offense. They're still before the court. And the magistrate is a human being, and as human beings, we all have preconceptions and assumptions, right? As a magistrate, you're not supposed to. You're supposed to be this wonderful person who is entirely impartial and never makes prejudgment about anything, right? But we have to be realistic. So you're always in your submissions trying to adopt the most persuasive phrases, tags that you can, right? So have a think about it before Monday about what you think would be the most persuasive label to attach to your client, the defendant, my client, or Ms. Wong, Ms. Wong. So don't worry too much about special or permanent magistrates, but I've just set out the differences for you here. But one thing I do want you to be aware of is, although we say that the maximum jurisdiction of the magistrate's court is 2 years, 3 years extension if the sentences are running consecutively, one after the other, there are specific statutory exceptions. One example is section 20, subsection 2 of the Firearms and Ammunitions Ordinance. That actually provides that if the defendant in his background has committed one of a certain number of offenses that are listed in the schedule, and theft is one of them, then even a magistrate can sentence the defendant to up to 7 years imprisonment. But there has to be that special statutory provision giving the magistrate that power. If there is no specific provision, then the magistrate does not have that power, okay? Another example is section 4, subsection 3 of the Dangerous Drugs Ordinance. Section 4 deals with drug trafficking. And we'll see that it's what we call an example of a dual offense. A dual offense is an offense that the prosecution has a choice. They can either charge it as a summary offense, and generally summary offenses are more minor, or they can charge it as an indictable offense. Indictable offense is more serious. If they charge the defendant with a summary offense, and so the case on drug trafficking is heard in the magistrate's court, then he can be imprisoned for 3 years, just for that one offense, right? We're not talking about section 57. So this is a special statutory kind of carve out exemption or whatever for drug trafficking with an extended sentencing power. So the magistrate's court is primarily a court of summary jurisdiction. And actually, it's the only court of summary jurisdiction. The district court and the CFI are what we call courts of indictable jurisdiction. And I'll explain that a little bit more in a bit. All offenses in Hong Kong are summary offenses, unless they are specifically stated to be triable upon indictment or to be indictable. So you have to look carefully at the wording of the section that creates the offense. Look at the statutory provision to determine whether it's a summary offense or indictable. So the magistrate's court generally hears all of the summary offenses, but there are very special scenarios under which the district court, or very exceptionally the CFI, may hear a summary offense. Besides the summary offenses, though, the magistrate's court can also try some indictable offenses. There are some indictable offenses that are what we call indictable offenses that are triable summarily. In other words, even though the statutory provision tags them as being indictable, they are able to be tried in the summary jurisdiction of the magistrate's court. And to determine that, we have to look at the second schedule of the magistrate's ordinance. So magistrate's ordinance, unfortunately, is very long. You go all the way to the back, and then you find the second schedule. So I've summarized it for you here. Well, I haven't summarized it. I've copied and pasted it for you to make it really easy for you. Here's what the second schedule says. So the rule is that any offense, any indictable offense that is listed in part 1 of the second schedule cannot be tried in the magistrate's court, right? So if it's an indictable offense and it is in part 1 of second schedule of the magistrate's ordinance, it cannot be tried in the magistrate's court. So you can see an offense punishable with death, right? Murder, right? Now, in Hong Kong, we no longer sentence people to death, but this provision still exists in our statutory provisions. But you can also see 2, any offense which is punishable with imprisonment for life. Okay, so if it's an indictable offense like murder, the maximum sentence is life imprisonment. It cannot be tried summarily in the magistrate's court. But you can see in brackets, there's a carve out. It says, except an offense against section 10 or 12 of the theft ordinance. So section 10 is robbery. If you look at section 10 of the theft ordinance, robbery is an indictable offense. The maximum sentence is life imprisonment. Okay. But because of the carve out, it means in part 1 of the second schedule, it means that it can actually be tried summarily in the magistrate's court. Okay. You see here, offenses endangering national security punishable with imprisonment for life cannot be tried in the magistrate's court. Part 3 lists the offenses that cannot be tried in the district court. So we'll come back to this in a minute when we get to the district court. So if you have a question about the jurisdiction of the courts and whether a particular offense can be tried in the magistrate's court or not, right? Your starting point is first look at the statutory provision, look at whether it's summary or it's an indictable offense, and all offenses are summary unless they're specified to be indictable. So that's stage 1. Stage 2 is you go to the second schedule of the magistrate's ordinance and you see whether it's the type of indictable offense that can be tried summarily in the magistrate's court. So if it's an indictable offense, let's say theft, right? Maximum for theft is 10 years. That's the maximum sentence of imprisonment. It's not in part 1 of the second schedule because it's not an indictable offense that's punishable with imprisonment for life. So that can be tried in the magistrate's court. Okay? The magistrate's court also houses the juvenile courts. So we'll take a look at the juvenile offenders ordinance. But the juvenile court hears charges against children under the age of 14 and then against young people under the age of 16, except for if it's homicide. We know from evidence law that there is this presumption of doli incapax, right? Do you remember that from your evidence classes? And there is the presumption that children under the age of 10 are not guilty, not able to be guilty of criminal offenses. Juvenile court will try offenses against juvenile in its summary jurisdiction, or it can hear it in its indictable jurisdiction. But where an adult is also charged along with the juvenile, then there's a slightly more complicated scenario. So that's section 3, the subsection 2 of the juvenile ordinance. We'll look at that later. But the aim of the juvenile court is that it offers a wider range of sentencing options against juveniles, because for a juvenile, really, imprisonment should be the last resort. So in the juvenile court, for instance, the judge, the magistrate is able to fine the juvenile's parents, right? Which is horrifying to me as a parent of 2 badly behaved children, that they could do something and I could be fined for what they've done. But that is within the power of the juvenile court. So section 3C, subsection 2 of the juvenile offenders ordinance lists situations in which it may be more appropriate for the magistrate's court to hear the case, even though a juvenile offender is involved. So you can see here, I've put it for you. Subsection A, a court of summary jurisdiction, in other words, the magistrate's court, shall hear a charge where a juvenile is charged jointly with a person over the age of 16. So the reason for that is it is preferable that if two people are charged jointly with committing an offense, that they are tried together so that the same facts, the same evidence is presented before the trier of fact and the trier of the law, right? You don't have disparate evidence being presented. You don't have different conclusions being reached. But you can't have an adult being tried in the juvenile court because the juvenile court only hears cases against defendants under the age of 16. So for this reason, if a person under the age of 16 is jointly tried with an adult, the magistrate's court has to hear the case. On the other hand, though, if the juvenile is charged with an offense arising out of circumstances which are the same as those which arise out of an adult, but they're not jointly charged, then the magistrate's court may hear the case, or there may be split trials, right? So the juvenile may be tried in the juvenile court, the adult tried in the adult court, in the magistrate's court. In the juvenile court, though, it's a lot more informal than in the other courts, right? Because you're dealing with young people. So as an advocate, you sit to make your submission. When you make your bail applications, we're going to be in the adult court. So you're all going to have to stand up and make your bail application. You don't get to sit down. But much less formal, the media are not really allowed in. You don't use the same formal terminology. And there's certain restrictions on exactly when a juvenile case can be called. District court. So your first appearance for a defendant will have been in the magistrate's court, and then the prosecution may have asked to transfer it to the district court. So you can see then, if that occurs, then the charge sheet would be filed in the district court and the defendant will be arraigned, right? Arraigned is basically the same as taking a plea. It's just a different terminology. So plea is taken from him in the district court, and we know on that first appearance, he's only asked to indicate his plea of guilty. If he pleads not guilty, then there'll probably be a pretrial review, and then off to the trial you go. And I've summarized the stages of the trial for you, which we'll talk about later on. On the other hand, if he pleads guilty, then he'll be convicted, and the judge may adjourn sentencing to call for pre-sentencing reports. This can happen in the magistrate's court as well. Plea and mitigation will be made, and then he'll be sentenced. So district court is a court of indictable jurisdiction, and it only hears cases which have been transferred to it from the magistrate's court. If the offense is an indictable offense, then the magistrate cannot refuse the prosecution's transfer application. Why? Because he has no jurisdiction to do so. That's section 88(1)(a). You can see by the language, the magistrate shall transfer the case. On the other hand, if it's a summary offense, the magistrate may refuse to transfer the summary offense to the district court. So the district court hears indictable offenses as long as they are not listed in part 3 of the second schedule. So if we go back to part 3, you can see paragraph 2, any offense which is punishable with imprisonment for life, except, and then we have a whole long list. So because of the except, it means that the following indictable offenses, even though the maximum is life imprisonment, they can be tried in the district court, right? So you can see here we have some offenses under the immigration ordinance. We have section 4 of the dangerous drugs ordinance, which is trafficking. We have section 10, or 12 of the theft ordinance. We have section 17, which is wounding with intent of the offenses against the person ordinance. So in other words, more indictable offenses with a maximum of imprisonment for life can be tried in the district court than in the magistrate's court. And that makes sense because the maximum sentence that can be imposed in the district court is 7 years. So it has higher sentencing jurisdiction. So it makes sense that a lot more indictable offenses can be tried there. So if the magistrate has agreed to transfer a summary offense along with an indictable offense, a district court judge can also hear the case of a summary offense, but the magistrate may refuse to transfer the summary offense. And if he does so, then the summary offense will be tried in the magistrate's court and the indictable offense in the district court. The magistrate will usually agree to transfer the summary offense along with the indictable offense where the offenses are related to each other, right? Perhaps they're sort of similar in nature, or they arise out of the same set of facts, or they occurred on the same occasion, right? So where it makes sense for them to be tried together, then the magistrate may agree to transfer the summary offense. The maximum is 7 years, even if consecutive sentences are being imposed. So remember, for the magistrate's court, we saw that a magistrate had that extended 3-year jurisdiction for consecutive sentences that he's imposing. There's no such provision for the district court. So maximum is 7 years, that's it. But when we get to the lecture on sentencing, we'll see that if the judge is going to sentence a defendant to a period of imprisonment, the first thing that he does is he imposes a starting point. And then from that starting point, he either increases it for aggravating factors or he reduces it for mitigating factors. And then he arrives at the ultimate sentence that he's imposing. In the district court, a judge can actually adopt a starting point that's higher than 7 years, as long as by the time he's taken into account the mitigating factors, the ultimate sentence that he imposes is 7 years or less. Okay, we'll look at the case that provides that as an authority. In the district court, you address the judge as Your Honor, and there's no jury, it's just the judge. So he's the trier of fact and the decider of the law as well. And we refer to the charged person as the defendant from the prosecution's perspective. Now, it's important to get your terminology right when you are addressing the bench. If you refer to a magistrate as Your Honor or Your Lordship, they will be so happy. You have promoted them up to a higher court. But if you refer to a district court judge or a high court judge as Your Worship, you have demoted them. So you're off to a bad start. Now, you never want to show your inexperience, right, by using the wrong mode of address from the very beginning. So when you're starting out, just in big font, colorful red letters, top of your papers, make sure you get the correct mode of address. I have been called in the past Your Excellency, Madam President. What else have I been called? Your Lordship, obviously not. But yeah, try and get your mode of address right. And then the CFI. So appearing first in the magistrate's court, the prosecution may apply to commit the case to the CFI. Then, if so, the indictment is filed in the CFI. The indictment is basically the same as the charge sheet. So what would have happened is, for the defendant's first appearance in the magistrate's court, the charge sheet would have been drawn up by the police. And then if the case is going to be committed to the CFI, a separate indictment would be drawn up. But the indictment just sets out the charge, the offense, and the particulars of that offense against the defendant. And then we still have similar proceedings if it's going to trial. But you can see here that following the closing of the case, the judge will then sum up the case, sum up all the evidence that's being called in the case and give directions to the jury. The jury will then retire and they will give the verdict. So the judge decides on the legal arguments. He's the trier of the law, but the jury are the fact finders in the case. They decide on the guilt or innocence of the accused. And the jury are not involved in the sentencing. Only the judge decides on the sentence. So actually, the jury are never told anything throughout the trial about what is the maximum sentence that the accused can receive if they convict him. They're not told about what the likely sentence is. I remember many years ago, one of my friends sat in a jury trial in a robbery case, and it was a very serious robbery case. And after they convicted, and he was the foreman of the jury, after they convicted the accused, he asked me, well, what's the maximum sentence that this guy could have received? And I said, life imprisonment. He was like, right? He was like, oh my gosh, I can't believe that. In other words, had I known that, I may not have convicted him. So that is the reason why the jury are never told about the sentence. It's not their role, and actually it doesn't go to what they are there to decide, which is the guilt or innocence. So court of first instance is, like we said, court of original and appellate jurisdiction. It can be the court of trial if the case has been committed to the CFI from the magistrate's court. And it primarily hears indictable offenses. It only hears summary offenses in very, very limited scenarios. So I put it for you here, section 79F. I don't think you need to worry too much about it, but this is, we touched on it briefly in evidence law. This is a special proceeding. It's called a notice of transfer. This is a provision that the prosecution can use where they want to commit a defendant to the CFI on an expedited basis. They can use this notice of transfer provision. But this is really the only way in which a summary charge would ever end up being heard in the CFI. And it's reserved for sexual assaults on children or mentally incapacitated people. So in the CFI, we're generally hearing very serious indictable criminal offenses: murder, manslaughter, rape, etc. Usually you have 7 members of the jury. Very exceptionally, you may have 9. And there is this provision in section 42 in which 2 judges in a jury may hear a case. It's so rare that I have never come across it in any of the cases that I've looked at or in practice. So don't worry too much about that. Just remember that generally in the CFI, it's the jury and a judge. And you address the judge as either my lord, my lady, or your lordship, your ladyship. In the district court and magistrate's court, the person charged is called the defendant. But in the CFI, they use the terminology of the accused. Why? Because they are, before the jury, stressing much more the presumption of innocence. In other words, you are accused of a crime, but the prosecution still have the burden to prove it, right? Whereas the term defendant can seem much more like you have this burden to defend yourself, whereas that's not the case. Okay, but in magistrate's court, district court, you're before a professional judge who obviously understands very well the burden and standards of proof. Okay, but in the CFI, when you are before lay members of the public, they are very focused on using this term of the accused. What about the NSL? So actually, offenses endangering national security can be tried in magistrate's court, district court, and CFI. If the case is going to be tried in the CFI, then the Secretary for Justice can issue this certificate directing that the case be tried without a jury and instead be tried by a panel of 3 judges. So there is a pool of judges who have been designated as able to try national security cases, and 3 members from that pool will be selected to try the case in the CFI. So a couple of years ago, you will have remembered this provision being hotly debated in some of the cases involving the Occupy Central protests, whether in Hong Kong there was a right to a jury trial, because previously, before the NSL, whenever there was a trial in the CFI, it was always heard by a jury. So what this case here, Tong Yik Kit, establishes is there is no general right to a jury trial in Hong Kong. And if there's ever a conflict between the national security law and our general criminal provisions, then the national security law prevails. So what it means is that when the case concerns a national security offense, there are 2 possible modes of trial. There is still the possibility of a trial by jury. And in fact, that is still the default provision, okay? But the Secretary for Justice has the option to issue the certificate for trial by a panel of 3 judges. And so far, for every national security case that has been tried in the CFI, the SJ has issued the certificate. We have not yet had a criminal case in the CFI being tried by a jury in a national security offense-related case. Another recent decision as well was about whether it was appropriate for overseas counsel to represent a defendant in a national security case. And this counsel here, Timothy Owen, who's a very well-known, very prolific British counsel who's appeared in many, many cases in Hong Kong in the past. But Jimmy Lai, who I'm sure you're all very familiar with, wanted him to represent him in his defense with all of the various offenses that he's charged with. And so what actually happened in this case was that the courts basically, in the Court of Appeal, they found in favor of Jimmy Lai and said that he could be represented by this overseas counsel. The Department of Justice then tried to appeal it to the CFI, but the problem was they tried to raise new arguments that had not been heard in the court below. And the CFA is not a second bite at the cherry, right? You cannot suddenly raise new arguments for the first time before the CFA. So that's the basis on which they declined to interfere. Then the government asked for an interpretation of the law, and the decision came back that we don't need an interpretation because actually our existing laws already covered the position. So basically, the current position is that there is no blanket ban on overseas counsel representing defendants in national security cases. But before an overseas counsel can apply to be admitted, first of all, the chief executive has to have issued a certificate stating that this is an appropriate case. So in other words, without the certificate, overseas counsel cannot represent a defendant in a national security case. So the takeaways from the NSL when it comes to trials in the CFI are 2 modes of trial. General default is a jury trial, but the SJ can issue the certificate for trial by the panel of 3 judges. Now it's solely the SJ's decision whether to issue the certificate, and so far they always have. And the basis on which they justify their decision, they can argue that, in other words, it's appropriate for the safety of the jury members, or that there are matters of great national security that need to be protected. Those are the arguments that they make in applying for the certificate, but it is their decision and their decision alone. And the defendant cannot object on the basis that the SJ has issued this certificate. There's no right of appeal. The only possibility is for the defendant to apply for a judicial review of the SJ's decision because it's viewed to be a prosecutorial decision. And it's a very high threshold to apply for judicial review. So it has not succeeded so far in challenging the certificate for trial by the panel of 3 judges. All right, so on to the Court of Appeal. So the Court of Appeal will hear appeals from the CFI and the District Court. And then there's a variety of different provisions, which we'll look at in Lecture 6, in which the Court of Appeal can hear other cases as well. And the Court of Appeal can grant leave to appeal to the CFA. CFA replaced the Privy Council post-1997, so it's now our highest Court of Appeal. In the Court of Appeal, if it's an appeal against conviction, it's heard by a panel of 3 judges. But in the CFA, there are 5 judges. But the CFA's ability to hear an appeal is very restricted in nature. So you have to be able to show that it's a point of law of great and general importance, or that substantial and grave injustice has been done. So there's no right of appeal to the CFA. And just to help you when you're doing your research generally, I just included this little refresher on what we call the doctrine of stare decisis. This is the doctrine of binding precedent, right? Which you may remember from your first year, right? So in other words, this is which decisions of which level of court are binding on the other. So I've summarized it for you here. So if you look at point 2, decisions of the Court of Appeal are binding on lower courts. So magistrates, districts, CFI are bound by decisions of the Court of Appeal, and the decisions of previous Court of Appeals are binding on the current Court of Appeal, unless those decisions were given what we call per incuriam, right? We like to throw around fancy Latin phrases as lawyers because it shows how much money we've spent on our legal education. But per incuriam means without considering binding precedent. In other words, the previous Court of Appeal got it wrong because they weren't referred to binding precedent. So what I'm going to do is I'm going to leave it there because I have talked for a very long time. Let's take a break and let me see how much more we have to cover. What I'd like to do, I think, is take a 10-minute break, and then I think we can probably get through the rest of the material in the second session, and then we can finish a little bit earlier. We'll see how we go, because we're going to talk about arrest, which is an important topic, okay? So let's take a 10-minute break, and let's resume at just before 8:45, okay? All right, let's resume. So in the carry on, we're talking a little bit about the scope of the prosecutor's decisions, the role of the Department of Justice. So generally, it's the Secretary for Justice who commences proceedings, although, of course, in practice, that's only one person and they have to delegate that role to other people within the Department of Justice. But there are also other government bodies that are able to commence proceedings as well. For example, the Immigration Department, Customs and Excise, ICAC. It's not a governmental body, it's an independent one, but it's also authorized to commence proceedings. General principles: the Department of Justice should not be influenced by outside people or any political figures in making its prosecutorial decisions. And an individual prosecutor must be fair, impartial, and independent. So if you look at paragraph 3 of the prosecution code, it sets out the duties of a prosecutor. For example, as a minister of justice, their objective should not be to secure a conviction at all costs. And that's based on the presumption of innocence and the concept that prosecutor is supposed to be independent and impartial. Prosecutors should also consider the views of the victim. So they should keep the victim fully informed of the progress of the case, consult the victim. For example, if the prosecution are thinking about negotiating with the defense, maybe offering no evidence on the condition that the defendant is bound over, which we will look at in a later lecture, then they should consult the victim about that. And they should also have their views brought to the attention of the court. For example, if they have decided to forgive the defendant for the crime that he has admitted he committed, then that can actually be put before the court and is actually a very valuable mitigating factor from the defense perspective. So you can take a look at these two documents, the Victims' Charter and the Statement on the Treatment of Victims and Witnesses. From the defense perspective, in the magistrate's court, the defendant may be represented by what's called the duty lawyer service. So it is a very wide panel of solicitors and barristers practicing in Hong Kong who sign up to be members of the duty lawyer service. And what that means is, instead of being instructed by a solicitor from a law firm, they can be instructed directly by the duty lawyer service. And all defendants who are eligible can be represented by the duty lawyer service on their first appearance in the magistrate's court for free. After that, if they wish to continue using the duty lawyer services, then it's a means-tested approach, and they just have to pay $620, and the duty lawyer service will handle their entire trial for them. What we mean by eligible defendants is that there are certain proceedings that the duty lawyer service does not cover. For example, you can't be represented by the duty lawyer service for committal proceedings. So duty lawyer service, though, only provides representation in the magistrate's court and juvenile court. If it's a district court case or a CFI case, then you have to see whether you are eligible for legal aid. And legal aid is a means and merit-based test. It is available in the magistrate's court for committal proceedings. So the aim of the duty lawyer service in legal aid is obviously to offer representation to defendants who otherwise could not afford to mount a comprehensive defense in their favor. So when it comes to the investigation, like I've said before, this may be conducted by a number of different departments, which may ultimately end up charging the defendant. But what we're going to focus on is how the police ultimately reach at their decision to charge a suspect. So we have obviously an investigation, and ultimately, if the police are going to arrest a suspect, they must have either a reasonable belief that the suspect is going to be charged with an offense or a reasonable suspicion of guilt. That's like the foundation of their power to arrest. And once arrested, they must bring the defendant before a magistrate within 48 hours. And then also, following that first appearance in the magistrate's court, like we've looked at already, then the prosecution will take over the case and decide, is it staying in the magistrate's court? Will it be transferred to the district court or committed to the CFI? So let's look at the police's powers. So police have powers both at common law, but the main statutory provision that you have to be familiar with is the Police Force Ordinance. But basically, any Hong Kong person must be arrested lawfully. A search must be conducted lawfully. And that's set out in the basic law as well as in the Bill of Rights. But the police have two primary powers in the Police Force Ordinance. The first is what we call their power to stop, detain, and search a person. The second is their power of arrest. So you have to be familiar with sections 54 and section 50 of the Police Force Ordinance. Let's look first at section 54. It comes later in time than section 50 in terms of the drafting of the ordinance, but it usually precedes an arrest. So section 54 is the power of the police to stop, detain, and search. And by the way, it should be obvious from the title, but the Police Force Ordinance only applies to police officers. It doesn't apply to general members of the public. So in a minute, when we talk about a citizen's power of arrest, they don't derive that power from the Police Force Ordinance. They derive it from the common law and other statutory provisions. So Police Force Ordinance, under section 54, police officer can, under section 54, subsection 1, if the person is acting suspiciously in any street, public place, vessel, or conveyance, then they can stop, demand ID, detain them for a reasonable period for questioning, and if necessary, search the person for anything that may present a danger and detain them for a reasonable period. So it's a power to stop, detain, and search. And in subsection 1, it's a person who's acting in a suspicious manner. Right? How do we determine whether that person is acting in a suspicious manner? It's essentially a subjective test. Right? It's whether the officer himself thinks that this person is acting in a suspicious manner. But we'll see in a minute how the case law has qualified that subjective test. So there's no power of stop and search at common law. The police only have the ability to do this because of this provision in section 54 of the Police Force Ordinance. A general citizen on the street does not have the power to stop you, ask you questions, and search. Subsection 2 says that if a police officer reasonably suspects that a person has committed or intends to commit or is about to commit an offense, they can stop, ask for ID, detain them for questioning, search the person for anything of value to the investigation, detain them for a reasonable period to carry out search. So the search is of the person, okay, under section 54. It's not a search of the surrounding premises in which the person is stopped. There is no power of arrest in section 54. This is just a power to stop, detain, and search. There's also no power of seizure. So they can search, but they cannot take. In order to arrest and to seize, they have to come within the provisions of section 50, because section 54 doesn't give them this power. But you can see that there's a difference in the wording between subsection 1 and subsection 2. What is the difference exactly? Subsection 1 and 2 are different in their reason for stopping the suspect. Subsection 1 is a subjective test. Does the officer think that this person is acting in a suspicious manner? Whereas subsection 2 is an objective test. Do they reasonably believe that this person has committed an offense? The search powers under the two subsections are also different, because under subsection 1, the search power is much more limited. The officer can only search for anything that will present a danger to the officer. So with that, we're talking about large items, guns, choppers, right? But subsection 2 is wider, anything of value to the investigation. So that could be opening up a cigarette box to look for drugs inside. It could be looking at a USB, right? Small items, looking at something inside a wallet. That's of value to the investigation potentially. But there is this case Wong CM, and that deals with this subjective test, because it would be very easy for a police officer to say, well, I thought that he was acting suspiciously, even if you don't. That's my subjective belief. Therefore, I had the power to stop, detain, and search him under subsection 1. So this case provides that when the officer reaches this subjective judgment that someone is acting suspiciously, he must be able to point to objective facts to form the basis for that subjective suspicion. It's not enough for him just to say, I thought he was acting suspiciously, right? The question which must follow is why, based on what? Was he acting furtively? If so, in what manner? Hiding behind cars, etc. This case actually arose in the context of a defendant who'd been arrested multiple times by the police in the past. And so his allegation basically was that they were biased against him whenever they saw him, and therefore they didn't have this subjective suspicion. But the officers were able to point to the circumstances prior to the stop, detain, and search in which he was seen acting furtively on the street late at night, hiding behind cars, behind the corners of buildings, looking like he was up to no good. So they were able to point to objective facts which founded the basis for that reasonable suspicion. There's some other stop and search provisions as well. The ability to search for stolen goods in cars. You may be familiar with the provisions of the immigration ordinance, right? Every time I walk through central MTR, pretty much, I see some police officers stopping someone and asking for their ID card, right? Usually the provision that they are proceeding to make that request under is section 17C of the immigration ordinance. They can stop a person and ask them to produce their ID card for inspection. But this case of Nka Lun establishes that this power only exists in connection with an immigration-related offense. So in other words, they have to suspect that some kind of breach of stay provision has been breached in order for them to stop and ask for ID. There is no search power under this section, but if the person who stopped doesn't produce their ID card, then under 17D, they can be arrested. And as part of that power of arrest, obviously the police have the power to search as well. So section 54, just stop, detain, and search. But the power of arrest is much wider in scope. And the power exists both at common law, but also has statutory basis as well. And a person can be arrested either with a warrant or without a warrant. So a warrant is the formal document that's issued by a magistrate or a judge, which gives the police or the department the power to arrest a defendant. So there has to be an application made before the judge setting out the basis on which the warrant is requested. Then the decision is made, the warrant is issued, and then they have lawful authority to arrest. But there's also the power to arrest without a warrant as well. By arrest, what we mean is that you are detaining someone against their will and making it clear to them that they are not free to go. So section 50, subsection 1A of the Police Force Ordinance is the police's primary power to arrest someone without a warrant. So they can arrest any person who they reasonably believe will be charged with or reasonably suspect of being guilty of any offense for which the sentence is fixed by law, or for which a person may, on first conviction, be sentenced to imprisonment. So when they exercise this power under section 50, subsection 1A, they have to have an offense in mind, because they have to have a reasonable belief that the person is going to be charged with this offense or a reasonable suspicion of guilt. And it has to be an offense for which the sentence is fixed by law, like murder, for example, or that you can be sentenced to imprisonment. Now, that's pretty much any indictable offense. So this is a very broad power. The leading case on the scope of section 50, subsection 1A is the CFA case of Yeung May Wan. And that holds that the reasonable belief has to mean on the basis of a reasonable suspicion of guilt. So it has to be more than just a mere possibility of guilt, and it's both a subjective and objective test. So the officer who's arresting needs a genuine suspicion that an offense has been committed based on objectively reasonable grounds. They can't just rely on another officer saying to them, go and arrest this person. That doesn't provide objective facts to form this reasonable belief. But on the other hand, if the senior officer has said, this person is suspected to have done this, this, and this on this occasion, and given the details in the form of a proper briefing, and then issue the instruction to arrest, then that can form the basis of the reasonable belief. So Yeung May Wan is actually a case about some protesters, and they're protesting outside the liaison office. And they were originally charged with obstructing a public place because they had some kind of banners, and there was a number of them there. So the police arrived and arrested them for obstruction. And when they were taken to the police station in the police van, some of the protesters resisted. One protester bit one of the fingers of the officers. Some of the protesters refused to get out of the van, so they had to be dragged out with force. So besides the original obstruction charges, they were then subsequently charged with either resisting arrest or obstructing an officer in the due execution of their duty. So they face like two different kind of sets of charges. So the question for the Court of Appeal and the Court of Final Appeal was, what do we mean this reasonable belief that an offender is going to be charged with something? Because in the Court of Appeal, their convictions for obstruction in respect of their original protest were actually quashed. So all that then remained was the later charges of resisting arrest and obstruction of a police officer in due execution of the duty. And if the original arrest was unlawful because there was no reasonable suspicion that an offense had been committed, then the subsequent charges had to fall away as well, because the officers were not acting in due execution of their duty when they made the arrest, because they did not have the reasonable suspicion that an offense had been committed. Why not? Because they hadn't been given a proper briefing. They'd just been told to go and arrest these people at the scene. So there was no reasonable suspicion in the mind of the arresting officers. And because the later charges, an element of those charges was that the officer had to be acting in due execution of their duty, if they weren't acting in due execution of their duty, because they made an unlawful arrest, because they had no reasonable suspicion that an offense had been committed, then an element was missing of the later charges. So those charges had to be dismissed as well. So they were acquitted of those charges. So I don't think you need to worry too much about the facts, but you just need to understand that this reasonable suspicion of guilt has to be based on objective factors. So we have this concept that an arrest has to be lawful, but I want you to be aware of the fact that even if the arrest is unlawful, it doesn't necessarily mean that the defendant will be acquitted. Right? We don't have this kind of fruit of the poison tree principle in Hong Kong, like they do in the US. US, if there's an illegal search, the beginning of the investigation, everything that follows in the case is clean. We don't have that same concept in Hong Kong. So the admissibility of each piece of evidence is looked at individually. In Yeung May 1, the unlawful arrest did lead to the defendant's acquittal on the subsequent charges, but only because of the element of those subsequent charges, the due execution of duty not being satisfied. But you can't necessarily say that every time there's an unlawful arrest, the defendant's going to be acquitted. Okay? You have to look exactly at what transpired. You have to look at the elements of the offences charged. So the courts still have jurisdiction, even in the context of an unlawful arrest. But of course, if the arrest is unlawful, then there may be other consequences. It may be that the defendant takes out a civil claim against the officers, or it may be that the officers are convicted of assault. It may be that complaints are made against the officers to the complaints against police officers, ACO. It may be that they face disciplinary proceedings. It may be that a confession that's obtained as a result of the arrest is inadmissible. So there may be various other consequences. So I think you can read this next slide yourself, just other powers that exist to arrest without a warrant as well. Let's move on to a citizen's power of arrest without a warrant. This is a topic that appeared, I believe, in either last year's main exam or the research exam. And I thought that this was like a given, like it was an easy question that all students would score like maximum points on. I was really surprised at the number of students who didn't know this provision and thought that general members of the public have no power to arrest another person on the street. Actually, most people in Hong Kong don't know that they have the power of arrest. Why? Because the provisions are quite complicated and the average layperson is not going to go read the statutory provision. And even if they did, they're probably not going to understand what they can arrest for, right? Because which member of the public knows what is an arrestable offense? So that's why in Hong Kong, we don't typically see citizens' arrests being performed, right? We're very happy when we see a crime being committed to whip out our mobile phone and film it and post it on Instagram or Snapchat or something. Wow, look what happened to me on the way home, right? But we don't generally, unless it's something very serious, tackle someone to the floor and restrain them against their will. But there is this power at common law to arrest for a breach of the peace. So if you see a scuffle taking place on the MTR, you do have this common law power to arrest for breach of the peace. You also have a statutory power to arrest someone under Section 101 of the Criminal Procedure Ordinance who you reasonably suspect is guilty of an arrestable offense, right? But why does no one know what's an arrestable offense? Because it's not even specified in the Criminal Procedure Ordinance. You have to go to the Interpretation and General Clauses Ordinance and look at what we mean by an arrestable offense. So basically, where the sentence fixed by law or for which you can be sentenced to imprisonment of more than 12 months, right? So we're talking about assault, theft, wounding with intent, any offenses like that. You can arrest someone, even if you were just a citizen and not the police. The police also have this power under Section 101, right? They're also citizens. But they don't need to rely on it because they have much more extensive powers under the police force ordinance than a general citizen. If you do ever perform a citizen's arrest, then by subsection 5, you are supposed to deliver the person you have arrested to an officer so that they can be brought before the court. Now, of course, in reality, how do you deliver a person to the police officer? You don't pull them by their hair through the MTR concourse all the way to the police station. You deliver them by making a phone call to the police and restraining them until the police arrive. But the common law principles also apply. So we'll look at this case of Christian Lichinsky. A citizen generally also has the duty to inform the person why they're arresting them, although it would be quite unlikely if the citizen was to say, I am arresting you pursuant to the provision of the criminal procedure ordinance, right? But of course, if the person's trying to escape or it's not practical to inform them, there's no need to tell them what the reasons are for you arresting them. And if they would know the reasons anyway, because it's obvious, because they've just punched someone in the face, again, you don't need to tell them what the reasons for the arrest are. So these are the powers of the police and general citizens to arrest without a warrant. But of course, there's also the ability to arrest with a warrant. And this basically just allows the officer to arrest without having seen the offense committed, without having to justify this reasonable belief, etc., because that's already all set out in the warrant. They can just go straight armed with the warrant, locate the person and arrest them and bring them before the court. On arrest, there's also the ability to search the premises without a warrant. Under subsection 3, let's say that the police are trying to arrest someone and they run into a building and they go inside a flat and they lock the door. Now, the police officers can search that premises without a warrant if they reasonably suspect that the person they want to arrest is within those premises. It doesn't give them the right to just randomly go anywhere in Hong Kong and do a search of the premises. They have to have a reasonable suspicion that the person they want to arrest is within those premises. And of course, they have to be able to explain why. They can even enter with force under subsection 4. Right? I'm sure we've seen on TV where they use the big battering rams, right, to break down the door. Quite difficult in Hong Kong because usually the doors are behind metal gates as well. So that complicates things slightly. But they first have to have identified themselves as police officers, demanded entry, said why they want entry, and been refused entry before they can just break in. And if they're stupid enough to get locked in somewhere, that they've gone in to arrest somewhere, then they can obviously break out as well. Subsection 6 is the provision that they rely on to search in or about the place that they are arresting a suspect, but also to search the person they're arresting themselves. And they can search for anything that they reasonably suspect to be of value to the investigation. So you can see here, subsection 6, they can search the arrested person or the premises. They can seize those items if they are going to be of value to the investigation. So under section 50, the power of arrest, the power of seizure as well. Now, in recent years, the issue has come up, to what extent can the digital content of a smartphone, for example, be searched? Because these basically hold our lives on these days, right? We have photos of our family, our pets, we have our bank accounts, our octopus card, our emails, our WhatsApp messages, right? The digital content of our smartphone is way more valuable than the actual phone itself, right? And that's what the officers really want to get into. But do they have the power to search the digital content of a smartphone without a warrant? So this is the leading case here, Sham Wing Can. And basically what Shamwin Khan says is that if the police want to search the digital content of a phone, they either need a warrant that they first obtained from the court, or if they don't have a warrant, they have to comply with the general common law principles. So they have to have this reasonable suspicion that an offense has been committed. The search has to be truly incidental to that reasonable suspicion. In other words, they have to have an offense in mind, and the search has to be connected to that offense that they are arresting for, right? It's not a wide-ranging ability to search for anything, any other possible unrelated offenses that the defendant could have committed, right? They have to be able to justify the scope of the search, and it has to be incidental to the offense that they are arresting for. They have to be able to show that it's not reasonably practicable to obtain the warrant. It has to be in relation to the investigation for the offense that the person is suspected to be involved in. It has to be either to protect the safety of people, or to procure and preserve information. So what they can do is they can do a quick flick through of the contents of the phone, but if they want to do a more detailed search, then it has to be restricted to these objectives. Now, it all sounds great in theory, doesn't it? But do you think that the defendant has the power to sit over the police officer watching him while he searches through his phone? Or do they take the phone, take it somewhere else, and then look through it, right? But if there is a challenge, the police officers have to be able to justify what they searched and why. And if they are trying to introduce into evidence extraneous material that is outside the scope of that search, then the likelihood is it will be inadmissible because they haven't complied with these common law principles. Now, I'm sure you're all wondering, what if the defendant refuses to give the password to the phone, right? Because our phones are usually always password protected or fingerprint protected or biometrically ID protected, right? So let's say that my phone recognizes my face, right? And I refuse to allow the police access to my phone. So what do? Have you ever tested whether someone can open your phone, like if you just close your eyes, right? If you hold your phone in front of someone when they're asleep, you try to swipe up, does it work? I tested it on my husband, doesn't. So if someone closes their eyes, you can't access their phone. And the police obviously can't force the suspect to keep their eyes open, right? And I thought about this in particular because I read this case in the newspaper about this group of criminals who'd gone into a bank in China with a guy in a wheelchair, and they had his phone, and they tried to convince the cashier to give them access to this person in the wheelchair's phone with, bank accounts based on the fact that they had the information in the phone. And they held the phone in front of his face and they kept trying to swipe up for the phone to open, showing the bank account details. And it didn't work. Why didn't it work? Because the person in the wheelchair was dead. So they couldn't activate the facial recognition software. So if your phone is protected with thumbprint ID, then what do? Do they forcefully take the suspect's fingers and put it on the phone? They can't do that either. That would be assault. If the phone is password protected, can the suspect be forced to give their password? So this case of Shamwin Khan says no. The police cannot compel the suspect to give their password against their will. And it's not obstruction of justice if they refuse to give their password. So this is why a defendant must be always represented by a lawyer, right? because the lawyer will advise them, don't give the police password. But what does that mean? So the police give up? So they say, oh, well, this guy's not going to give us a password to his phone, so we won't bother with looking at the digital content. Of course not. Right? What do they do then? They go and get a warrant to search the digital content. Now, how do they still get into the phone? They have very sophisticated IT experts who are able to crack into the phone based on the warrant. So that's how they get into the digital content. So Apple says they can't do it, but yet the Hong Kong police force seems to be able to do it. So it is possible. This case, Chukar-Keat, is an example of where the search went outside the scope of this reasonable belief that an offense had been committed. In this case, the police had actually found photos, not of the drugs that the defendant was alleged to have trafficked, but photos of other drugs. So they wanted to show that he's part of some kind of wider drug trafficking syndicate. But that's not what he was charged with. And so the extra photos were prejudicial and inadmissible. So you can also get a warrant, of course, to search premises under Section 50 to Section 7. So generally, search principles, you should only search without a warrant if it's reasonably necessary and reasonably impracticable to do so without a warrant. In other words, if the evidence is in danger of being destroyed, then that would give justification for searching without a warrant. If someone gives you consent to search the premises, you don't need a warrant because the consent has been given. And if the search is unlawful, then because there is no fruit of the poison tree, whether the evidence that's obtained on the back of an unlawful search is admissible or not depends. That's for the court to decide, weighing up whether the probative value outweighs the prejudicial effect. All right, under the NSL, we know if there's a conflict, the NSL prevails. But generally, under the NSL, you just have to be aware that the officers under the Department of National Security have much wider search powers, much wider powers to impose conditions. They can order an arrested person to surrender their travel documents, not to leave Hong Kong, whereas the general police under general criminal provisions cannot do so. And I put here some general points about searching under the NSL, searching the digital contents of the phone, etc. What happened in the Jimmy Lai case is that the police first obtained a warrant to search the phone of Jimmy Lai. He argued that there was confidential information on it that was not covered by the warrant. So they then went off back to court and got a better warrant that did cover the scope of their search to allow them to search. He was arguing that there was what he called journalistic material on his phone, and that the police should not be able to search. And the court said, only material that is covered by legal professional privilege is exempt from ability to search. If it just falls within general journalistic material, it's not covered and it can be searched under the warrant. So let's talk about some general principles. As part of a lawful arrest, a person arrested has to be informed of the reasons for their arrest. In other words, they have to know why they're being arrested. So that comes from the case of Christie and Lichinsky, but there's some exceptions. So when an officer is arresting a person, they have to inform them of the true reason for the arrest. right? They can't arrest them for something minor in nature when really they have a much more serious offense in mind. If they don't inform them of the reasons for arrest, then there is the potential that the officer is committing assault or false imprisonment. But if, because of the circumstances, it's not possible to inform the person why they're being arrested, it's impracticable to do so because they're trying to escape, or if they already must know the reasons why they're being arrested, they don't need to be informed about the reasons for the arrest. And when the officer's arresting, he doesn't need to say, I'm arresting you for the offense of theft pursuant to Section 9 of the Theft Ordinance, right? He just has to make it clear in simple language that the person is being arrested and for what. Right? I'm arresting you for shop theft. But if they're not informed of the reasons for the arrest, you can cure it by informing them of the reasons for the arrest a short time later. That's the Kulinich case. And failing to inform the defendant of the true reasons for the arrest may lead to the confession being ruled inadmissible later on if the defendant makes the confession. So remember, courts still have jurisdiction, but there may be many other consequences which follow from an unlawful arrest or an unlawful search. When the person has been arrested, they must be delivered forthwith to the officer in charge of the station. That's Section 51 of the Police Force Ordinance. Now, the officer in charge of the station is what we call the duty officer. They are an independent officer. They're not connected with the investigation. They have what we call an occurrence book in which they log everything significant that happens in the course of that day. And the idea is that by taking the arrested person before the duty officer, the arrested person has the opportunity to complain about unlawful conduct by the arresting team. So if they've been beaten up or induced in any way, they can complain to the duty officer. Now, what does it mean by forthwith? It doesn't mean immediately, but the police have to be able to justify a delay. So in the Yeung Kar-ki case, this was a case in which a woman was befriended by a group of people. They basically duped her. They took her to one of these holiday homes in Cheongchao. And originally they planned just to take her ATM card and go to the bank account and withdraw money because they forced her to give them the password. But then they realized that actually, if they let her go, she would identify them. So they ended up murdering her. And they left her body in the holiday villa, and they went off and they took all this money out. And then her employer, I believe it was actually Hong Kong U, reported her missing. Police launched this investigation, tracked the ATM card, were able to identify the suspects, and then followed them to this holiday villa in Cheongchao when they went back to retrieve the body and dispose of it. But when the police arrested the suspects, they didn't take them directly to the police station. They first of all took them up to the rooftop and they held them there for several hours. Now, the police said the reason they did that was to preserve the crime scene, because by this time, members of the media had gotten wind of what's happening because they listened to the police scanner radios. So there was a lot of like paparazzi all around the holiday villa. So that's the reason they didn't deliver forthwith. So the court said, technically, this provision was breached, but it wasn't enough to render the defendant's confession involuntary. So we have under Section 52 as well, this 48-hour rule. Within 48 hours of the defendant's arrest, he has to be brought before a magistrate. And the magistrate then decides on the question of bail or not. The police can also grant bail. So we'll look at that tomorrow night. But whether the police grant bail or not within 48 hours, the defendant has to be taken before a magistrate who then makes a decision on whether to grant court bail or not. And when we're talking about the rights of an arrested person, we have to have in mind this very important document, the 1992 Rules and Directions. Yes. I don't think so, because this case is primarily about whether a confession that was obtained should be involuntary, right? And in order to be involuntary, you have to establish like a climate of oppression, or you have to establish threats or abuse or inducement, right? So if we're just thinking about this climate of oppression, was taking them to the rooftop for 3 hours really a climate of oppression in the circumstances, right? Actually, it may be that their rights were far more oppressed if they're dragged on display before the media on their way to the police station, right? So probably in that case, that's why they were able to justify such a long delay in the circumstance. Okay, right to silence. We're going to talk about this more in a subsequent lecture, but as a general provision, no obligation on a defendant to answer questions or to incriminate himself. But we know it's not an absolute right. If he does remain silent, though, the court should not draw any adverse inference from that. Because if we think about it, if you remember back to the rules and directions, right? Rule 2, when arresting a person, they have to be cautioned. So they should be told, you have the right to remain silent. You're not obliged to say anything, but if you do, it can be used in evidence against you, right? That's the caution. So imagine a scenario where defendant listens to the caution. He's told by the police officers, you have this right to remain silent. So he takes up that right. And then later, it's used against him to say, well, you must be guilty because you didn't answer questions, right? It makes nonsense of the whole Rule 2 caution. So that's why if we have this provision or this principle that the right of silence should not be used against a defendant if he chooses to exercise it. But it's not absolute. There are certain situations in which the judge can comment on really the only evidence of this defense must be within the knowledge of the defendant. Therefore, you would have expected him to raise an explanation. We'll talk more about the right of silence later. So what about in making this arrest? How much force can be exercised? So when we're talking about a citizen's power of arrest, Section 101A, such force as is reasonable in the lawful arrest, right? It's so vague. What does that mean? Such force as is reasonable. It's a question of fact in the individual circumstances of the case. How much force is reasonable? So I see someone, I don't know, spitting on the floor of the MTR. I don't even know if that's an arrestable offense. It's probably not even, right? But let's say it is, just for argument's sake. How much force is reasonable for me to use in performing a citizen's arrest, right? Is it reasonable for me to block this person's exit from the MTR? Probably. Is it reasonable for me to put my hands on them, stop them from leaving? Minor offense, right? We're starting to push the boundary of what may be reasonable. Is it reasonable for me to chase after them, tackle them to the floor? No, I think we can all agree, right? Not for a minor offense. Sit on their head so much that they stop breathing? No. So here am I, one day, sitting in my apartment, quietly working. I hear this massive commotion outside on the street. So I look outside and I see a taxi abandoned in the middle of the street, all the doors open, and two guys scuffling on the street. And I can see that there's this elderly gentleman, his hair's gray. And then I see this younger man wrestle him to the floor and sit on his head in an effort to restrain him. So at this point, I'm like, what is going on? This is a true story. So I go downstairs, and it transpires that the taxi driver and the passenger have gotten into a dispute because the passenger is claiming that the taxi driver is taking too long to drive him and deliberately taking a longer route, and the fare's going up and up. So he spat at the taxi driver. And the taxi driver then, so furious, turned around, went to punch him inside the taxi. The guy jumped out of the taxi and started to run down the road, at which point, that's what I saw, the taxi driver tackling the guy to the floor and then sitting on his head. Now, essentially, he's performing a citizen's arrest. But the question is, how much force is reasonable in doing that, right? It's reasonable, I think, for him to restrain him with the use of force, but to sit on his head to the point at which this person is not breathing, right, which is what I saw when I first arrived, is not reasonable in the context. When we go back to the underlying nature of what happened, which is a dispute over a fare in a taxi, and then a possible minor assault of spitting. Okay, so it's always a question of fact and the circumstances. Now, I don't know what happened in that case, but I suspect it's likely that they both ended up getting charged with offenses, right, of assault. Under Section 50 of the Police Force Ordinance, a police officer can use all means necessary to effect an arrest. So this is much wider in scope than the citizen's power. So that's why I said, even though the police have the citizen's power of arrest too, they don't need them, because what they have under the Police Force Ordinance is much wider. So what is all means necessary to effect the arrest? Does it mean the officers can use handcuffs? Yes, it's possible. But all that the guidance that we have is that it's a value judgment of the individual officer. In other words, again, it depends on the circumstances. So you have to look at how serious is the offense that the person is being arrested for? Are they attempting to resist arrest? Were the use of handcuffs really needed? Now, if the offense is very minor and the police use handcuffs anyway, when they shouldn't have, because they didn't need to use all means necessary, then what's the relevancy of that? The relevancy is that it can start to provide the basis for a climate of oppression for you then as defense counsel to argue that any later confession is involuntary because of the oppression that was exerted at the scene of the arrest. But you're going to have to argue that the offense was minor, the circumstances didn't justify the use of handcuffs, and you may need other oppressive conduct as well. When the arrested person arrives at the station, they have to be processed. And as part of that processing, they have their photo taken, their fingerprints taken, their general weight and height. But anything more than that has to be justified. So can't take footprints, for example, unless it's going to help the investigation of the offense. Hard to imagine what offenses that would assist in. I don't know, a barefooted burglary, maybe, or an assault in a patch of mud or something, barefoot. Maybe you need the footprints for that, but otherwise, no. In terms of your role as a lawyer, obviously, you need to make sure that the police have complied with all of their duties and that your client's rights are protected. So when they are processed at the station, they should be given what's called a Poll 153. That sets out all of their rights. So they're told that they have the right to stay silent, that they have the right to legal representation. And once they've been processed, then at some point the OC case, who's the officer in charge of the case, will want to question them. Now, ideally, you would like to have been instructed as their lawyer before that questioning takes place, so that any questioning that's done, if they consent to it, is done in your presence, and you could advise them whether to answer questions or not. But at some point, the police have got to make a decision whether they're going to give the person they've arrested bail or whether they're going to keep them in custody until they are brought before a magistrate. So your role really depends upon the stage at which you're instructed. If you're instructed to do a legal visit, then that's usually very early on in the case. And then you're going to advise the defendant about their rights, make sure that the police know that you're their legal representative, that they shouldn't be questioning them without you present. You may need to take instructions for a bail application. And if you get to the police station and the police say, yes, we have your client in custody, but you're not allowed to see him, then it's really important that you make inquiries as to the reasons why you're being denied access. Because Direction 8, a person of the rules and directions, person in custody has the right to legal representation, but it's not absolute. So that access can be refused in certain circumstances, but the police have to be able to justify it by saying that it's going to hinder their investigation or obstruct the processes of justice. So as your lawyer, you need to understand why the access is being refused, make a note of it, ask to speak to the duty officer, etc. You may be instructed to attend an ID parade, and we'll talk about identification because it's an important topic later on. But if you were instructed to attend an ID parade, then you obviously need to make sure that the ID parade is fairly conducted, that there is no opportunity for the participants in the ID parade to see your client before he comes into the ID parade, that the ID parade is conducted by an independent OC parade officer. You have 8 actors plus 1 defendant. But there's no obligation for your client to take part in an ID parade. But of course, if he doesn't, the police won't give up. They will use some other method of identification. And that other method may be more prejudicial. So it may be a confrontation ID, where the witness is taken down to the cells and they walk up and down the corridor and they're asked to look into the cells and do they see the person that they saw committing this offense. That's a confrontation ID. Most prejudicial form of ID is the dock ID, right? Because there's a tendency to believe that the person in the dock must be the person that they saw. So I've put here for you some practical tips about ID parades if you have to attend one in practice. I think you can largely read these through yourself, but if you ever are instructed to attend an ID parade and you arrive and you discover that actually the 8 actors in the ID parade look nothing like your client at all, your client has got orange hair and they all have black hair, or true case, your client is the only one wearing a yellow raincoat and everyone else is wearing black, so they stand out like some kind of beacon of light in the middle of the ID parade, then never agree for your client to go through with it, right? You can refuse for the ID parade to take place, right? It's a voluntary participation. It's not mandatory. So in that situation, you would say to the officer, the OC parade, this ID parade is not properly constituted, right? These are the breaches. You need to fix these. We're not taking part in this ID parade today. We request that you organize another ID parade at a mutually convenient time and date, right? Get it right next time. Never agree to your client taking part in a prejudicial ID parade. These days, most ID parades are videoed. So the potential for these kind of abusive situations are much less. 1992 rules and directions, just to finish with. So read them, of course. You should have already read them for evidence. but refresh your memory of them. Remember their guidelines. They don't have force of law, except for Principle E, which does. Principle E relates to the voluntariness of the confessions. If the police don't comply with the rules and directions, then the confession may be inadmissible. But just because they breach a minor provision of the rules and directions doesn't mean that the confession will be inadmissible. You must have a copy of the entire rules and directions with you in the exam. Okay, so print it out and take it with you. The rules and directions apply not just to police officers, but to any people who are charged with investigating offenses or charging offenders, any law enforcement officers. So customs and excise, immigration officers, ICAC officers, agriculture, fisheries, conservation department officers, right? If there's suspected animal abuse, animal cruelty cases, they can make an arrest, they can bring a charge. They also have to comply with the rules and directions. But a citizen, rules and directions do not apply. The security guard in your building, rules and directions do not apply. They are privately contracted security guard. They're not a law enforcement officer. So important provisions, right to communicate with a lawyer, but not absolute, qualified right. As soon as there's enough evidence to prefer a charge, the police must immediately charge the person. The reason for that provision is so that they don't continue to ask prejudicial questions of the suspect when they should charge them, so that it's a protection for the suspect. And when they're being charged, they have to be cautioned as well. And it's only in very specific situations that when a suspect has been charged, the police can continue to question them. Basically, to clarify an ambiguity, they can ask them additional questions after the charge. Principle E, you know about already, relating to the voluntariness of the confession. So I've just set out for you here key provisions of the rules and directions. You know Rule 2 already. This is the caution, the need for them to make a contemporaneous record. Do you remember the case of Fung Wing Ching from evidence? Remember? The boy who's stopped by the police officer. He's only 15 years old. He's got a bag on him, and the officer asks if he can look in the bag, and then he sees these packets of white powder. The officer says, "What are these?" And the boy says, "Ah, sir, they're drugs, and I have more on the hillside. I'll take you there." Right? So the question in this case is, when should he have been cautioned? And in this case, technically, there was no breach of the police in failing to caution him as early as they should, because he volunteered the prejudicial information himself. "Oh, I've got more on the hillside." Because more on the hillside is, we're going not just in a case of possession, we're going into a case of trafficking now, because we have a much larger quantity of drugs. And he actually revealed as well in his "Sir, I have more on the hillside," that I've been asked by my big brother to carry these drugs and give them to other people. So that's a case of trafficking. But this case is also important because remember, the boy's only 15. The officer took him to his home, spoke to his mother. The mother said, "Oh, shall I come to the police station while you interview my son?" And the officer said, "No need. I'm going to take good care of your son." So that was a violation of Direction 5, because a person under the age of 16 who's being interviewed is entitled to have their parent or guardian or another person of the same sex present during the interview. And this was a serious breach of that Direction 5. So what that meant is the boy's written record of interview was excluded for the breach of Direction 5, but we still have the problem of the oral confession. And that was found to be admissible, even though there was a caution that was given late in time. So I've also put a couple of cases for you here on late cautions. You can take a look at those. Rule 3 deals with Principle D. As soon as they are charged, they must be immediately cautioned and the circumstances under which additional questions can be put after the charge. Rules 4 and 5 deal with written statements and records of interview. So they must have the chance to read over the statement, the ability to correct it or add anything to it. It has to be an accurate record of the interview. So if the interview is in the question and answer format, the officer has to accurately record what it is that the suspect is saying back to them. Rule 6 is very important. Remember, this is a rule of evidence. The out-of-court statement of a co-accused is only ever evidence against them. It's not evidence against the defendant. So this is what Rule 6 is directed towards. If a co-accused has confessed, the police can show your client the copy of their confession, but they cannot invite reply or comment. They can't say something like, well, B has confessed and he says it was all your idea. What do you say about that? That's inviting a reply or comment. And that would render B's subsequent or A's subsequent confession inadmissible. So we have to have reasonable arrangements for the comfort and refreshment. Here's our direction 5. So far as practicable, right? So this isn't an absolute right for the child to have their parent or guardian present. Imagine the situation where the parent or guardian is suspected of also being involved in this offense. It would make nonsense to have them present during the interview of the minor, right? Now, in the Feng Wing Ching case, it was practicable to have the mother there because they'd even gone to the house. But if the mother can't be located or is in another jurisdiction at the time of the questioning, it's not practicable for them to be there, but some other alternative arrangements should be made. Direction 6, very important. Interviews should be conducted in the mother tongue of the suspect. Now, in practice, what does that mean? Is the police officer expected to speak Urdu or some obscure African dialect? Of course not. It means, though, that they have to wait for the interpreter to be present if the suspect is unable to communicate in the language of the officer. Now, there is one particular obscure African dialect in Hong Kong. I can't remember the name, but there is only one interpreter in Hong Kong who is qualified to provide interpretation services. So this interpreter has to be present at the interview with the police and do the translation back and forth, but also then has to be present if the case goes to trial and also provide interpretation services then. So is there this possibility for prejudice? Potentially, because you're using the same interpreter at multiple different stages of the proceedings and with different goals and roles in mind, right? When an interpreter is present in court, their function is to assist the court, right? That's their primary purpose, to be impartial, to accurately translate and interpret. But when they're there at the police station, there's more of a connection to the defendant, right? Because they're listening to the defendant's story. So, but that's the reality, right? If there's one person who can interpret, there's one person who can interpret, okay? And if the defendant is, or suspect is giving his statement in another language, right? Then the statement that he's asked to sign can't be in a different language that he can't read. So when I was the victim of a theft or attempted theft one morning in Yamate MTR station, very early in the morning, I was obviously quite dazed and confused. I had a big bright red wallet. I'd just taken money out of the ATM machine, so I was a prime target, talking on my phone, waving my wallet around in the air. Some guy tried to snatch it from me. So he didn't succeed. I reported it to the police. I got taken to the police station. I was interviewed. there wasn't the officer actually asked me questions in English. He didn't need an interpreter, but he wrote up my statement in Chinese and asked me to sign it. And so, of course, I refused. I couldn't read the statement. How do I know what it said? So then he finally, wow, like, God, now we have to get someone to interpret. What a hassle. What a pain in the butt to have to comply with these rules and directions, right? So the interpreter arrives, and question one was, did you know the person who tried to grab your wallet? They never asked me that. Question two was, did he seem to be under the influence of drugs? My answer, yes. I was never asked that either, right? The officer just assumed that based on the timing, it was early in the morning, it was a young guy, he looked quite disheveled as I had described him. He just assumed it must be some guy high on drugs. But see, this is the danger of signatures being obtained to statements in a different language. You have no idea what it is that you're signing up to. And we, as the public, assume that our officers are going to be honorable and accurately record what we say, right? And to his credit, he probably wasn't trying to do anything dishonest. He just made a natural assumption. But those questions weren't asked and answered. All right, direction 8, right to communicate with a lawyer provided no unreasonable delay or hindrance is likely to be caused. So if other suspects are still at large, stolen property hasn't been recovered, someone's been kidnapped, they haven't yet found the person, those are all legitimate reasons for denying access to legal representation, commonly denied in a triad-related offense, because there are some solicitors, lawyers in Hong Kong who routinely defend triad-related offenses and members. So the police, therefore, may have a suspicion that they are a conduit for passing on information. So generally, in connection with a triad-related offense, you may be denied access to the lawyer. But of course, you need to have it all documented as the lawyer. Okay. So 5 to 10, I think we can finish there. Are there any questions before we end? Is the Correctional Services Department a charging officer? No, the Correctional Services Department are charged with looking after the people in custody. So I don't think they bring charges against suspects. Any other question? If not, I will see you tomorrow and we will tackle bail, which is a big subject. So if you can do any reading in advance, I think it will help you out. All right? See you tomorrow.